having me. I'm an estate planning and probate attorney here in Austin, and before I went to law school, I was a high school teacher for 3 years. And I remember when I turned 18, my parents for my birthday bought me a will. They sent me to a lawyer. Yeah, I was like, I would have loved that car, but thank you. So they sent me to this lawyer downtown. And I went in the office and they had already written everything for me, and I didn't know, really what any of it said or what any of it meant. And I remember that it was like kind of dark and there was like a lot of leather and wood. And I was just like, what am I doing here? And you have to sign all these documents in quick succession. And I didn't really know what they meant or what I was signing. And it was just like very overwhelming. And so when I went to law school and I decided to get into estate planning and probate, I decided that it was really important for me to have a different kind of practice where people felt comfortable asking questions, where people felt empowered, that they were signing documents that they had understood, that had been explained to them clearly, so that they could make informed decisions and feel comfortable. And that's the whole point of having an estate plan, is feeling good that you have a plan. So there, any uncertainty that's, you can't control everything. You don't know when bad things might happen, but having a plan gives you peace of mind. So yeah, if at any point you have questions, or if I'll have time at the end for Q&A, but if at any point anything is confusing or I'm unclear, ask me a question. I'm happy to just discuss. I made the slides, so I'd have something to say, but we don't have to follow the slides if you want to talk about something else. So I've got a plan for that. Let's do it. Okay. Cool. So, what is an estate plan? So ideally, your estate plan should cover 3 scenarios: incapacity, emergency, or death. And I think as women, oftentimes what we think the most about is, well, if I pass away, who's going to take care of my kids? But there's more to it than just that. That's part of it, but there's more to it than just that. We want to make sure that if you get into a serious accident, who's going to manage your finances and make your medical decisions? Or if by some crazy situation you have a traumatic brain injury, who's going to take care of you? Who's going to be in charge? And then, of course, after you pass away, where will your property go? Who's going to take care of your kids? Who's going to make sure that your property goes to the right place? So the estate plan is not just a will or a trust. There's powers of attorney and other documents all involved. I also want to mention that I talk about death and dying all day. So I'm a little desensitized, and if I say a hypothetical that sounds really dark, I promise it's just a hypothetical. But I mention it just because we don't think about this happening unless you know someone that it's happened to, or unless you watch like a scary movie and then you have like a bad dream about it. But so I've mentioned these things not to bring you down, but just because I've seen every scenario that I described today is something that I've seen. So yeah, not to scare you. Also, I am a lawyer, I do private practice, but I'm hoping that when you leave today, you'll know about some resources that you can check out that are free and available online. So I'm not trying to get you all to pay me a bunch of money. I'm trying to empower you, if the situation is appropriate, to help, to make your own plan, or so that you can feel empowered. If you do want to hire an attorney, you'll know what questions to ask and what documents that you need. So just so you know. Okay. So there are times where someone can make their own plan, but there are also times when it's not appropriate to make your own plan. And kind of the main issues where if this is you really do need to talk to an attorney, is if you have minor children or a child with special needs, even an adult child with special needs. If you have a blended family, so if either you or your spouse, it's not your first marriage, then it's important to talk to an attorney because that can be really complicated. If you want to make charitable gifts, it's helpful to talk to an attorney about it. If you're making gifts to people who are not your adult children, like if you're making a gift to a niece or nephew or to a sibling, that can create complications. If you have more than $2 million, you start to get into kind of like risky tax territory. So you will need an attorney. If you have a toxic family or a complex family situation, or if you have a privacy concern, for example, one of my clients has a stalker and has a huge privacy concern. And so we put all of her assets into a trust with a secret name. And hypothetically, this is not the real name, because I can't tell you what the name is, but it's like the Gummy Bear Trust. So her house, the deed is under the Gummy Bear Trust. So if her stalker tries to look her up, there's no property in her name. It's all in her trust. Most people don't need a Gummy Bear Trust, right? Most of us aren't walking around with stalkers or with privacy concerns. But if you do have some kind of situation like that, or if you're worried about an ex tracking you down or whatever kind of risky situation, that's another time that you would want to talk to an attorney about setting up your estate plan. But yeah,
I'm just gonna say one other thing. And maybe.
Yeah.
I'm a single, I'm widowed, I have kids, I have family, I have. So, I need a will because I just thought if I die,
yeah, where's it gonna go? Yeah, we will talk. I have some like pretty charts that talk about that, but yeah, you need a will because otherwise it's gonna go under what the state says where it should go. Your closest heir at law, which could be a sibling. Hey, yeah. Yeah. Let's say that you wanted to make your own plan and you were like, well, I just want to give everything to my best friend, Beth. Well, that's pretty simple. If Beth's an adult, then that's a pretty simple will that you could probably get away with making yourself. But if you want to split it up into eighths and 1/8 goes to charity and 1/8 goes to your whoever, well, then it gets more complicated and it's more likely that there will be some kind of issue. Like, do we have a contingency for if any of those 8 predecease you? And if so, where does that go? And if there's no plan in the document, then it will go to your brother in Ohio. So, so yeah, if it's a simple thing, you could probably figure it out. But if it's not, then you should probably talk to a lawyer. That's true too. Good point. Wow. Just proving my point for me. Thank you. Yeah. With that being said, who can probably write their own estate plan? A single person with all adult children with no special needs, great. A married couple where it's their first marriage and all their adults are children and they're staying married forever, easy peasy. A single person with no children who wants to give everything to one adult person, pretty simple. Or married couples with no kids who give everything to each other and then to like one other person. These kind of really simple things, you could definitely figure that out yourself. But if there's any kind of complicating factor, then you should probably talk to a lawyer. But if you do want to try making your own estate plan, and you'll see this link twice, there is a free website called texaslawhelp.org. And they have a ton of forms online. Specifically, the State Bar of Texas approved some simple will forms for people who want to write their own wills. They've been pre-approved by the bar. So you could just download that form from this site and try to go through it and write it yourself. And that is a free option that's out there. I will say I do find the will document, those forms to be pretty confusing to navigate. Like they have a bunch of like if or things that you're supposed to delete and take out. So I find that form to be tricky. But what I mean, I don't really advise this. I'm not giving you legal advice. This isn't legal advice. It's all hypothetical. But the most common wills that I see go through that people have written themselves are handwritten wills, fully handwritten. It's called a holographic will. It has to be fully in your handwriting. And the main things you need to think about are naming an executor, the person who's going to be in charge of all your stuff after you die, who it's going to go to, and you need to make sure that you give everything away. Don't just say like, my house goes to John and my car goes to Amy and my bank account goes to William. You need to say, and everything else that remains that I own, the residue of my estate goes to my kids or whoever. So you need to make sure that you give everything away and that you have an executor and that you sign and date it and that you say that it's your will. And those documents, which are called holographic wills, these handwritten wills, usually do okay, like being admitted to probate and passing through. And we'll talk more about that in a minute. Go ahead. long as your will is if it's compliant with Texas law when it's made, it'll work in another state. It's helpful when we talk, I think next actually, yeah. When I talk about these documents, these kind of ancillary documents, those are important to have a new one if you move to a different state. But your will should still work in any state as long as it's a valid will under Texas law when it's written. So I talked about emergency, incapacity, and death, and we'll talk more about wills in a minute, but I want to take a minute to mention the emergency and incapacity documents, and you may have heard about these. So in Texas, we have a statutory durable power of attorney, which is the financial power of attorney. And this document shares authority with another person to make financial decisions and make transactions on your behalf if for any reason you can't do them yourself. And these documents are all available online at texaslawhelp.org. You just search power of attorney, and you can download all these forms and fill them out. You just have to get them notarized, and they're very easy to do yourself. Attorneys do prepare them, but these are great forms. And whenever clients call and they just need a quick thing, I'll usually tell them, like, honestly, you could probably just do it yourself for free. So these documents are important to have, and you can do them yourself. It's just, you just have to get them notarized. Read the directions carefully, obviously. The main reason why these documents fail when people prepare them themselves is because they didn't read the directions on how to execute the documents. So for the statutory durable power of attorney, you have to do some initials, you have to cross something out. But if you don't do those things, then it's confusing. So just read the instructions. But the power of attorney, the statutory durable, is financial, and it authorizes someone to make financial decisions for you if for any reason you can't make them yourself. This document is really important because what if, and I think about this more in the context of an aging parent. What if your parent is getting older and needs help with their finances? They're not incapacitated, they're still kind of with it, but they want some help and they want you to be able to call the bank or pay a bill every now and then. You need this document. And if they do become incapacitated, if they get dementia or Alzheimer's, then you have this in place. They did it while they were healthy and while they were with it. And that gives you continual access to their bank account to take action for their benefit. The same is true about a medical power of attorney. Medical power of attorney shares decision-making authority for medical decisions with another person. So if for any reason you need medical treatment,
I just have a question about the power of attorney. If there's a bank account, and let's say your parents put your name on there, does that take precedent over these forms?
Depends. So different banks have different rules about what that means. You could be a co-signer on the account, or you could be a co-owner, or you could be a pay on death. It depends on how the names are titled on the account. And that's something that would be on the signature card that you fill out when they add you in the bank. That's an internal bank document. So if you're just a co-signer or an authorized signer on the account, then a power of attorney would trump that. But if you hold the account in joint tenancy, if you're a joint owner of the account, then the power of attorney would only trump for half of what's in the account. It really is dependent on each bank, because sometimes having two people's name on an account means one thing at Wells Fargo, but it means something else at Bank of America. So yeah, look closely at that document, at the signature card. I will also say, and I should have mentioned this first, these documents, powers of attorney, HIPAA, all of those, these documents are only valid while the person who made them is alive. So the power of attorney's authority terminates when the person dies. So if I write my power of attorney and I name my husband, and then I name my best friend, my husband can access all my stuff and do whatever he needs to do with my money. And if I'm in a coma and I'm just laying there, he can pay my bills, he can, I don't know, pay my health insurance premiums and do whatever he needs to do. But as soon as I pass away, he no longer has that same access and authority. He loses that authority and he won't get it back until my will goes through probate. just to be clear. But on some bank accounts, when you put someone else's name on the account, if you're making them a joint owner with right of survivorship, then upon your death, the account transfers immediately to that person. So it just depends what exactly is on that signature card. Okay. Keep asking questions. Yeah. Well, that's a good question. Great question. In Texas, we are a community property state. So what that means is any property that I acquire during my marriage is going to be presumed to be community property, meaning that we each, my husband and I each own a 50% share in all of it. So if I make X income, he makes half X income. My X income isn't really mine, right? He gets half of it and I get half of his. So to a certain extent, you do get a benefit being husband and wife because everything that's in the bank account is going to be presumed to be community property. But if your bank is doing their homework and my husband goes to the bank and says, I need to take all this money out and, you know, I need to make a huge deposit, take all the money out, don't tell my wife, that's a problem because half of the money in the account is mine. And so you start running into issues. The bank won't take away your spouse's access if they already have access to the bank account. But let's say I have an account that's only in my name that I opened before we got married, and then I'm in my coma, and my husband tries to access that money to pay my bills. He won't be able to access the money. He needs a power of attorney, even though he's my spouse. Good question. Since we're talking about community property though, let me just clarify. So community property, everything that you acquire during your marriage is considered to be community property unless you inherit it or if it's given to you as a gift. So during our marriage, if my grandfather passes away and gives me a rental house, wouldn't that be nice? And that rental house is rented out and it's generating income. The rental house is my separate property. But the kicker is that the income off that property is community property. And yeah.
What about property before you?
That's also your separate property. But the issue is, and we're getting a little taxi here, so if your eyes glaze over, just zone out for a minute. So when you get married, what's yours before the marriage remains your separate property, but any appreciation in the value on that property becomes community property. And that's why divorce is so hard, because if you own a brokerage account or a retirement account or a house before you get married and you're married for 15 years, presumably you're investing that property wisely and that property is growing in value. So when you get married, you're not just splitting your bank account that you earned while you were married, you also have to split that gain on all your other separate properties. So that's why people like to do premarital property agreements or prenups, because they want to specify that their separate property is this hypothetical rental house, but also the income is going to stay separate and the appreciation and value is going to stay separate. That's the main purpose of a prenup, is to designate capital gains on separate property remaining separate. And so, like, just to give you a number example, if I get this rental house that I inherit from my grandfather, and when I inherit it, it's worth $100,000, but at the time when my husband and I get divorced, it's worth $200,000, then that $100,000 gain is going to be community property. So I'll owe him $50,000, even though the house is my separate property. Yeah.
What if the property is in a trust?
Okay, we're getting fancy. That's a great question. And to be, I'm hesitant to talk about this because trust can mean so many different things. There's so many different kinds of trusts. So let's use my grandfather example. My grandfather dies and gives me a rental house under his will, and he puts it into a trust for my benefit. That's called a testamentary trust, a trust that's created under someone's will after their death, testamentary. It's an irrevocable trust, meaning the terms of the trust are set in that document and they can't be changed. It's also a trust that's been created for me by someone else. I didn't put my stuff in there. Someone else put stuff in there for me. and I'm simplifying, but because of this trust, because it's a testamentary trust that was created for my benefit by someone else, it's a separate taxable entity from me, and I don't own it. I get the beneficial interest of it, but the trustee owns it, technically. And so anything that's given to me in a testamentary trust, because it's not my separate property, it's just something that I have a beneficial interest in, then technically that would be separate. And any income that's generated inside the trust by the house would be separate. And any appreciation would be separate because I'm not the trustee and I didn't put it in there. So I do get the benefit if it's in a trust, that if I got a divorce, this house in this trust and everything else in the trust would not be subject to a division order by the court in a divorce. So that's one reason why parents like to use a trust in their wills. Yeah. Yeah. Mm-hmm.
Or like
It's creditors, lawsuits, and divorce.
anything.
Yes, but I want to be crystal clear that this is not a trust that I set up for myself. So clients often call me and they say, I'm worried I'm going to get sued. I run a construction business and it's risky and there's contractors. So I want to make sure that I'm protected. Well, unfortunately, I can't set up a trust for myself and put all my stuff in it and say it's creditor protected, it's lawsuit protected, it's divorce protected, because that's something that I made for myself. I'm not exchanging ownership. So I'm getting real theoretical. In terms of ownership and trust, there's kind of three strings that you have to think about. Who is creating the trust? And that's sometimes called the settlor or the grantor. Who manages the trust? That's the trustee. And who gets the benefit of the trust? That's the beneficiary. So when you hold all three strings of ownership, what you have is a self-settled, revocable trust. It's flexible. And so you haven't given up any of that ownership. And so you don't get the benefit of creditor protection or asset protection. You have to give something up to receive that benefit. So why I specified that this testamentary trust wasn't created by me, it was created by someone else. So I don't have the benefit, these three strands of ownership. When you break a strand of ownership, you get a benefit of creditor protection and divorce protection. And I'm oversimplifying a little bit, but that is kind of a bird's eye view of the answer. So when people talk about trusts, there's lots of different kinds of trusts. And if you have a trust that's a separate taxable entity from you, which is usually a trust that was made by someone else for your benefit, or a trust you made for someone else's benefit, then those trusts are going to be, like I said, they won't be subject to a division order and a divorce. They won't be subject to creditor claims or lawsuits. But it's hard to get that because I don't want to give my stuff away to someone else just for it to be protected. I can't afford to give all my stuff away. I don't have enough money to do that. So really, when you get these creditor protected trusts, it's because you inherited it usually from someone else. Are we feeling okay about this? Anyway, I wish I had my other slides with me so I could show you. Is this clear so far?
Yes.
Oh, great. Well, great. Oh, okay. Well, since you said that, and then I promise I'll get back to the program. One other thing you should be aware of, and I think this is a term that people often think they know what it means because of the movie Legally Blonde, but it really doesn't work that way. I'm telling you, I thought this before I went to law school, and I'm talking about common law marriage. In Texas, we have something called common law marriage. And in Legally Blonde, Elle Woods confronts Dewey at his trailer on behalf of Paulette, get her dog back, and says, because you resided together for 10 years, you are in a common law marriage. And then she uses that to get the dog back. But that's not what common law marriage is. That's not what are the elements of common law marriage. It's actually way easier to be married by accident or not even know that you were married. And there's no such thing as common law divorce. If you're found to be common law married, you have to go through a real divorce in the court. So why am I mentioning this? Yes.
Say it, go to a hotel and say this is me. And the third is.
You're doing so good. Not quite. The 3 elements of common law marriage are that you cohabitate, and that could be you spent one night together. Well, you can spend the night, just don't do these other things. Look, I'm not trying to tell you how to live your life. The 3 elements are you cohabitate even for one night, that you hold yourself out to the community as married, and you agree to be married. So, for example, I have a client who didn't realize that they were common law married. So this person and her partner had cohabitated, they had spent the night together. On Facebook, they posted a pic of the 2 of them together, like in a cute pose, and it said wifey with a ring emoji. Like people do that. Oh my God, cute, wifey. And like they would commonly refer to each other as like my better half or like the ball and chain. And then the last one, agree to be married. So they had proposed to each other and they had agreed that they wanted to get married. And they said, we might as well be married, you know, feel like we're already married. And so that was enough for them to be found legally common law married. And so when they broke up, one of them sued the other one and divorced them and got half of community property, and they were able to trace their common law marriage back to the date of that Instagram post. So anyways, you can spend the night with your boo, but just don't tell everyone, don't tell everyone that you're married, don't refer to them as your old man or, you know, your old lady, and don't agree that you're married. Yeah, so just be clear what you are. Guys, this is getting fun and spicy, I like it. Okay, I'm gonna briefly give a rundown of the rest of these documents and we'll move on. So medical power of attorney, like I said, it authorizes someone to consent to medical treatment for your benefit if you can't consent yourself. The medical power of attorney is important because if you don't have one and you're in an emergency health situation, doctors need consent before they can perform treatment on you. And so, yeah.
I have one that's out of state.
Okay. It's not stupid. It's nice that you have one, but it's better to have a Texas one, and the form is available for free. Yeah. Just make, oh, that's fine. That's fine. They just need, no. Yeah, that's fine. That's totally fine. I thought you meant that the document was from a different state. Oh, yeah, someone who lives in Ohio, not your brother though. Yeah, that's totally fine. Yeah, it can be a person who's out of state, but I typically recommend to clients that you name a backup and their contact information needs to be on there. So if you are in a car accident and the medical team can't get a hold of this person in China, then they need someone to give consent. So they'll call the next person on the list. Yeah, or Ohio. So just name a backup who is in a similar time zone. Yeah, and talk to your friends or whoever this person is, whoever is the important person that you trust. Talk to them about your preferences or your lawyer. Oh yeah, talk to your lawyer. But it's going to be harder for the team to get, you know, they're not going to know who wrote this document. You need the contact information for the person on the document. So yeah. A HIPAA authorization. HIPAA is the federal law that protects your confidential healthcare information. So this document just authorizes clinics, hospitals, doctors, dentists to share your medical information with the people that are listed on the document. So your medical power of attorney needs to be listed on your HIPAA authorization. Yeah. Yes, absolutely. Yeah. And so both my grandmothers, one has Alzheimer's, one has dementia. And my parents have these documents for both of them, one for my dad's mom, one for my mom's mom. And this is like a really great segue to the Declaration of Guardians. I'm just skip through directive really quick. My mom's mom has Alzheimer's. She's the nicest lady in the whole world, and she just does whatever you ask. She'll take her pills. She trusts us. She's sweet, just a delight. My dad's mom has dementia, and she is like a tornado. She thinks that everybody's stealing from her and that everybody's out to get her. And she's convinced that her nurse is stealing her underwear. So it's tough with my dad's mom. With my mom's mom, we only need these power of attorneys. And my mom was able to manage her medical care, where she lives, her finances. It's great and it's easy. With my dad's mom routinely says, my kids are trying to kill me. My son is stealing from me. And so these documents, these power of attorney documents, they do not authorize the agent that's named, that is the person that you name to do those things for you. They don't authorize that person to do anything against your wishes. So my dad's mom doesn't want medicine. She doesn't want to live in a nursing home. She doesn't want nurses in her business. If it were up to her, she would never bathe, she would never eat, and it would be dangerous for her. So when you have a parent who's cooperative, you really only need powers of attorney, and that will get you very far. But when you have a parent that's combative, you really need a declaration of guardian. And the reason is because a guardianship under Texas law is the proceeding under which the court determines that a parent or an elderly person is incapacitated. And it's the proceeding, you're probably thinking about Britney Spears as much as you can, forget about Britney for now. It's the similar proceeding where your rights are removed. You lose your right to drive, your right to vote, your right to marry, and those rights are given to your guardian to decide. So for my dad's mom, she keeps trying to escape her nursing home and she hits the nurse and it's like a really bad deal with her. And so we need a guardianship of her so that we can say, no, you have to live here and they will keep you here. And we don't have the authority to medicate her against her wishes. Like, doesn't give you that authority, but it does give you the authority to access their bank accounts and take away their access. So my grandma kept giving her social security number away to people on the internet. And she was writing big checks, like to strangers. And it was like, oh my God, Nina, you need this money for yourself. You need this money for medical care. And so we took her access away to her bank account. And it's a serious, heavy thing, taking away someone's right, taking away someone's access to their own stuff. But occasionally in extreme cases, it's necessary. So that is what the declaration of guardian is for. Yeah.
The guardian.
So the declaration of guardian form is a form that you write while you're healthy. And you say, I, Carlotta Garza-Kilcullen, declare that if I'm found incapacitated, I name my husband as my guardian of my person. So to make my medical everyday life decisions. And if he can't do it, then I name my best friend, Sally. And of the guardian of my estate to manage my money for me, I named my husband, Austin. And if he can't do it, then I name Will, period.
But if the person is already in dementia.
Mm-hmm. If they're already in dementia, you can file for guardianship without this document, but it's a court proceeding. A guardianship is always a court proceeding, and the court will appoint a lawyer to represent your parent who's incapacitated and an investigator to make sure that there's no abuse happening. And there's like this whole system. And the point is to protect the person who's going to be under the guardianship and make sure that that's the right person. So all interested adult parties have to be notified. So all the adult children, any surviving siblings or parents have to be notified to make sure that the right person for the job is being appointed. So declarations of guardian are helpful if like you're worried that your crazy brother is going to try and get guardianship of you and you want to disqualify him. Or like if you don't want your mom to be your guardian. Like if you're single under the law, then it would default to an adult child or a parent. But your parents are probably much older. And so maybe you want to name a best friend instead. So the declaration of guardian lets you choose. Yeah. Going up one, the directive to physicians is a preferential document to express your preference about life support. So if you are in a terminal condition and you weren't able to direct your own care, you weren't able to speak or take care of yourself, you get to write this document indicating your preference about life support. Yeah.
I didn't follow him.
Yeah.
So if I come back to the have a probate and get all the hospital, how do they know?
That's a good question. Do you have an emergency contact on your phone by chance? Like that's set up? Okay, yeah. ICE in case of emergency. If you have an iPhone, there's a way to set an emergency medical contact that EMS will call. And then your emergency medical contact should be who's named on your medical power of attorney. So,
You can do that on.
okay, great. I don't have one.
They have to have access to.
No, the emergency medical contact.
I mean, the hospital would have to have access to your phone, and they would have to find that.
Yeah,
You.
well, look, I can't solve all your problems. There is a service that I have used with clients before. It's called, what's it called? I'll look it up. I think it's called Legal Directives. And they generate a little card that you keep in your wallet. And it has a PIN number on the card. And what you do is you pay a subscription fee. You send a copy of all of your executed documents to this company, so they have it. And then in your wallet, you carry this card. And I think it's like $30 a year to keep it up. And it has a PIN number on the card. So if EMS pulls your wallet out, they can call the number, give the PIN number, and get access to your documents. I'm pretty sure it's called legal enrollment or legal directive. And it's a service. There are similar services where you keep just a card in your wallet so people can get your documents. You can also on your phone designate an emergency medical contact that no one needs to be able to unlock your phone to access. So there's a couple of ways that you can do it. Most people don't keep their power of attorney documents in their pocket. So yeah, it's helpful if there's a way for someone to contact your emergency medical person, if it's card in your wallet or on your phone. And then your medical power of attorney should have a copy of your document. And that's true really of anyone who's named. Your statutory durable and your medical power of attorney need a copy. So yeah. And then declaration of guardian for minor kids is the last one on the slide. And that's for parents with minor kids. That's how you designate if both parents pass away, who would take care of your kids. And you have to name a guardian of their estate. So if they inherit money, who's going to be the manager of that money? And then the guardian of their person. And that's what we think of as like having custody of the kids, like who's going to live with them and take them to school and make their medical decisions. So parents of young kids are usually most concerned about the declaration of guardian for minor kids. Yeah. Yeah. Wait, so did your friend pass away and then you got the kids? Oh, I say, wow, you're a good friend. Did you do that for me? Yeah.
It's a big responsibility.
It is.
But I said I would pass away, and I didn't know you have.
Oh.
Nothing.
Wow.
And I'm just here to say, let's prepare for this stuff, because you just
Yeah.
don't know, I don't need to be more.
No, are you kidding? I talk about this all day. Yeah. Yeah.
Yeah.
Yeah. So anyways, all of these documents, like I said, are available online for free. And it'll take you a little time to kind of read through them and make sure you've checked the right box or signed in the right place, but they are there for free and they're great and you should really check them out. So that's my plug for that. Okay. Okay, so I want to talk a little bit about a will versus a trust. I think a lot of people have heard about, do I need a trust or do I need a will? And like I said earlier, there's lots of different kinds of trusts and it can be confusing. How do you know? So in Texas, most people have a will, not a trust. Trusts are becoming more popular because people are moving here from California. And in California, their probate system is very inefficient and it's unaffordable. But in Texas, our probate system is pretty efficient and it is pretty affordable as long as your will is set up properly and everybody gets along nicely. Not always true, but for the most part. And so, yeah, when I say probate, go ahead. Oh, is that your question? Great. let me tell you. Oh, no, that's not my next slide. I'll just tell you. So what is probate? Probate is the process of validating someone's will after their death. So while you're alive, your will is just a piece of paper. It doesn't have any valid legal authority. It's not enforceable until it goes through probate. So what that practically means here in Austin, we have the Travis County Probate Court. So when someone dies, their person that they trust grabs their will and they hire a lawyer, and that lawyer prepares an application to probate the will, and they send the original will with wet ink signatures on it, not a copy. It's got to be the original. They send the original will and the application and the death certificate to the court. And then there's a couple of kind of technical legal things that happen. And then you set a hearing. And at the hearing, the person who's named as the executor will take an oath and say, I promise that I will perform all the duties of the executor under the will. I promise that this is the last will that she ever wrote. This is the right one. She was of sound mind when she made this will, and I promise that this is the right one. So the judge will put a stamp on it and admit the will to probate. And at that time, the executor has legal authority to take action on behalf of the estate. So what action do they have to take? They have to collect all of your property. So that would be bank accounts, cars, personal property, your house, all your stuff. They collect it up. They pay off any debts or creditors. So like your last credit card bill and your final tax return. And then they distribute your property out to your beneficiaries, however they're named in your will. That's the executor's job. So in Texas, the process from the date of death to the date that the executor is appointed, it might sound like a long time, but it's very short. It's like 6 weeks. It's very quick. So in other states, it can take years. Like in Louisiana, 4 years is like really quick to go through probate. But in Texas, you can get an executor appointed within 4 to 6 weeks after the date of death if you're moving quickly. And on that day, 4 to 6 weeks after death, that's when the executor can use the funds in the bank account, hire a CPA, sign contracts, whatever they need to do. And so that administration process can take time, right? Like filing a tax return or paying debts or whatever. But it is a pretty short process here in Texas, and it is pretty affordable comparatively. Like in California and Arizona, it's very expensive, but here in Texas, it's not that expensive. So sometimes you'll go to a lawyer and say, I need an estate plan. And the lawyer will say, oh, okay, I'm going to set up a trust for you. It'll cost $10,000. Well, you probably don't need a trust. You probably just need a will. And lawyers sometimes like to sell you a trust because it's more expensive. They can charge more because it includes more documents, but you probably do not need a trust if you live in Texas and all your property is here in Texas. If you own a condo in Florida, you should probably get a trust, but otherwise you're probably fine with a will. And one of kind of my goals with this chat is that if you do decide to call a lawyer and talk about an estate plan, that you'll feel empowered to say, I don't think I need a trust. I really want to get a will. Yeah. Oh, no, that's it. Mm-hmm.
With that,
No. No. So assets that are beneficiary designated, like retirement accounts or pensions or like assets with restrictions on transfer, like Social Security benefits or veteran VA benefits, those will oftentimes not interact with your will at all. So a beneficiary designation trumps a will. A contract transfer, like a beneficiary designation, will take effect and the will won't have authority. So depending on the contract or what it says in the divorce decree about those documents and whether they continue after your death or if they terminate with your death, that's actually going to govern what happens to that, not your will. Yeah.
So do we need to, page it's all like, I don't know.
Yeah.
It's all just like and stuff.
Mhm.
Um,
So it's, if you have a password manager, that's that's awesome. Yeah, like I use 1Password. It's an online little like app where, and it generates like a crazy password for all of my stuff. So instead of being like Carlotta 123, it's like XQW3 or whatever. If you have a password manager, that is helpful, because your executor would gain access to your digital assets and then it's all in one place. But you don't necessarily have to do that, as long as there's some kind of record of where you bank. So if it's E-Trade, for example, they have, like, there's a setting on E-Trade where you can name a person to be able to access. But it's hard to know, like, if I'm named the executor and the person who's died only has electronic records and I don't have access to their computer. I don't know if they bank at E-Trade or Charles Schwab or Merrill Lynch or wherever. So when that happens, I'll often end up sending letters to just like 25 banks saying, I'm the executor for this estate. Here's the death certificate. Here's my letters from the court saying I'm the executor. Please let me know if you have it. And then it takes weeks and weeks and weeks. So it's helpful if the person that is your executor, it's helpful if they have like some kind of just like, yeah, hint, like leave a map, treasure map. That'll be on the death certificate. It'll be on the death certificate. You can get the death certificate, so when someone dies, it is challenging, yeah. When someone dies, there's usually, like, when there's a body, the funeral home will come or the crematorium will come, and they'll need to know who's the authorized signer who's the informant on the death certificate, who fills out all the information of the person who's deceased. And that person, it's statutorily regulated by the state of Texas who can sign that form and who can be the informant. And so you can either designate that person in your estate plan, or it's your closest heir at law. That person fills it out, and that's the person that can request the death certificate. And so you would get the social security number by getting the death certificate, presumably from the informant. And that should be someone that the executor knows that they can get in touch with. But yeah, you're right.
My mom has Spanish.
Oh. Yeah, that's really tough. Yeah. Yeah. I don't recommend giving your social out to just like. Shut up. Is that what? Yeah. I do. Thank you so much.
15 years ago, they put yourself here.
Just on them. Yeah. Yeah. I mean, if someone really can't find your social, they can usually get it. This is like not a suggestion. Don't do this. But if you're desperate and like a parent, you can usually find it if you go through their mail, if they have any kind of tax document in the mail, like a W-2 or a tax return. Yeah, you can usually find it somehow, but it is easier if like one trusted person has. And what I recommend to my clients is that they make, like you said, a 1-pager where it just says like, I bank at Charles Schwab and Bank of America or USAA and Merrill Lynch or whatever. And I have an IRA account at, I don't know, Mass Mutual, and I have this and that and a life insurance policy, and that's it. And that way they know where to start. If you work with a wealth advisor, or like if you have like a guy at the bank, right? Sorry. Kind of a big bug, sorry. Write that person's name down and their phone number or their email. Make a roadmap. But keep that document in a safe place. Like I recommend keeping it in a safe at your house, and like 2 people know the code. You know? Yeah. Okay. That didn't work. Okay. So what about a trust? So I don't recommend to most people that they get a trust. Most people in Texas just need a will, but some people do need a trust. For example, Oh, it's not on here. No surprise. I'll just tell you. So if you own property in multiple states, then you probably need a trust. Because the Texas probate court, the Travis County probate court can only govern property in Texas because each state has their own system. So if I, which I don't, but if I did own a condo in Florida and I died, my will would go through Texas, through the Travis County probate court, and then my executor would have to then go to Florida and do a probate in Florida. And the system in Florida is different and worse than in Texas. So when clients have property in multiple states, that's one reason that I might recommend setting up a trust instead of using a will. A reason why I might suggest setting up a trust instead of a will, like I mentioned earlier, is privacy concerns. So if you're worried about a stalker or like a crazy ex, or if you are a politician
Or a brother in Ohio.
or a crazy brother in Ohio. Or I had a lot of clients who are doctors, who are physicians, who didn't want patients looking up their house on TCAD, the Central Appraisal District website. You can look up someone's name and find their address and how much their house costs. And it's just like, I don't want my patients to know that. So if there's any kind of privacy concern, that's another reason why you might want trust. Yeah, so I do it all the time too, yeah. So it's good for privacy, multiple states. And the other reason why some people like it is because you can avoid probate if your trust is properly funded. So what do I mean when I say funded? Like, what's a trust fund? What does that mean? What I'm talking about is a revocable living trust. So when earlier I told you about like the 3 strands of ownership. So this is a trust where you hold all 3 strands. You create the trust for yourself. So you're the grantor or the settlor. You manage the trust, you're the trustee, and you receive the benefit of the trust, you're the beneficiary. And if you're married, then that could be you and your spouse for all 3. So you set up this trust, which is a revocable living trust. So it does not have a separate tax ID. It's connected to your same social security number. So it's not a separate taxable entity. You do not have to disclose it to the IRS. It does not impact your taxes, your income taxes. And you slowly but surely start putting everything you own into this revocable living trust. And I think about it like one of those big blue IKEA bags that fits everything inside of it. So you deed your house into the trust, and you put your bank accounts into the trust, and you put your brokerage account and your personal property, your furniture, your jewelry, all your stuff goes into this trust. And while you're alive, you have the trustee hat on and the beneficiary hat, and you have all 3 hats on. But if you become incapacitated, then the trustee hat comes off and gets put onto the next person that's named in the document. So, or if you pass away, you take off the trustee hat and you put it on the person who was named as your successor trustee. So people like the idea of a trust because there's no probate. It's all privately managed. You don't have to go through the court. You don't have to file an inventory with the court. Nothing is public record. And there's no gap in between the date of death and the access to the assets. So I talked about that 4 to 6 week gap through probate. With a trust, there's no gap because your successor trustee is already named and your property is already in the trust. But the problem with trusts is that if it's not properly funded, you still have to go through probate. So lawyers will prepare what's called a pour over will, which on the event of your death, if anything remains in your name and not in this IKEA bag trust, then this will serves just to pour anything that's forgotten into the IKEA bag. So you still end up going through probate to get to the point where the hat can pass to the next person. And so I don't typically recommend trusts for clients unless they really need them, because you prepare all these additional documents, assignments of your bank accounts, deeds to your house, all these extra work that lawyers get to charge you money for, but then clients don't ever get to the point where they're fully funded. And so unless you're really motivated and really on top of it and you've got the time to fully fund a trust, then it's just a more expensive version of a will. It's not really necessary. So that's my. Fully funded, meaning that everything that's in your name is no longer in your name, but it's put into the trust.
All in the IKEA bag?
All in the bag, yes.
If it's in the IKEA, then it's like the case we trust.
Mhm.
In the interest, can you consider it sitting in the child?
Yes, you can. And that might be a reason why people would like it. Like, if I were gonna make a trust, I might make it the CGK 2024 trust. Those are my initials. And then I could put my house in my trust and my bank account and all my stuff in there. But the process of doing that is very time consuming. It's administratively time consuming. And you deal with a lot of red tape. Most banks won't let you transfer your account out of your name into the trust and keep the same account number. Like, there are some banks that will let you, but most banks don't. Like USAA won't, Wells Fargo doesn't anymore. Bank of America doesn't play nice with trusts anymore. And so if you have auto pay, like on your mortgage or on your cell phone bill, then it disrupts because you get a new account number and you have to transfer it all over.
Administrative
Yeah.
stuff.
Oh, yeah. I'm not, look, if you want to set up a trust, set it up. The point I'm trying to make is, and I think the reason I'm talking so much about this is because there's a few law firms in town that are kind of notorious for selling people a very expensive estate plan that is overkill. And most people don't need such an intense plan because it's too expensive and they can accomplish the same thing for cheaper using a will. That's why I'm describing this process in such detail. So yeah, if you fit one of the criteria, like you have property in multiple states, you're concerned about privacy or whatever the case may be, then this might be your green light to consider creating a revocable living trust. If you do, though, please call a lawyer and have them do it for you because people mess these up all the time. Okay, I'm gonna keep going. Okay, so how much does an estate plan cost? It really depends and everybody's different, but it is expensive. For like a basic, simple kind of cookie cutter, married, 2.5 kids, white picket fence situation, it'll usually run like $1,750 to $3,000. If you start adding more complexity, the price goes up. If you're single, it goes down because you're not doing 2 sets of documents, you're just doing one. But estate plans are expensive. And so that's partially why I want to point you to those free resources, because a lot of people can get away with doing their own thing. But if there's a complicating factor, it's important to talk to a lawyer about it, and it's going to cost. It just costs money, unfortunately. So things that add complexity to your plan is if you have a blended family. So if someone in the relationship, it's not their first marriage. If you have a child with special needs, if you're doing any kind of sophisticated tax structure, those are all things that add complexity that could make your plan more expensive. What happens without a plan? Chaos. And so what I mean by that is the state of Texas has its own statute-based will. So people that die without a will in the state of Texas, well, the law tells us where your stuff will go upon your death. So let's talk about what that looks like. So when you don't have an estate plan, you have to go through an heirship determination, which is when the court determines who are your legal heirs, your heirs at law. The court hires an attorney ad litem. They appoint an attorney to represent unknown, incapacitated, or minor heirs. So there's 2 lawyers involved. And it gets really expensive. Even the filing fee for an heirship determination in Travis County, it's over $1,000. So it's a lot more expensive than filing a will for probate. So I want to show you some diagrams of what it looks like. So sometimes your heirs at law, they're not different than what you would want in your will, right? Like if you're married and it's your first marriage and you have kids, then under the laws, then your husband gets some and your kids get some. But if there's any complicating factor, then it can be really bad. And I'm going to explain what I mean by that. So Okay. So for example, my best friend unexpectedly had a heart attack in his 50s. And at the time he was married to his second wife and they had just had a young. So. He's something really close, really unexpected. So his second wife, you would think like, oh, second wife's gonna get a lot of money so she can take care of this little girl. And his older kids who were primarily gonna get less because they're both adults. That is not how it works. The laws in Texas really pay attention to kids and they don't specify adults. And in the state of Texas, minors can't own property in their own names. That's why if you want to open an account for a minor child, it either needs to be a custodial account or you have to be on the account because kids can't own property. So in my scenario, my best friend uncle who died, it was actually really detrimental to the surviving. Because remember, in Texas, we're a community property state. So everything that you acquire during a marriage is owned jointly by both spouses. So what does that practically mean? It means, so when there are children or other descendants outside of the existing marriage, so the adult kids that my uncle had before his second marriage, all the kids get his half of the community. So that joint brokerage account that he and his wife had been investing in, all of a sudden that gets split in half and given some to the older kid and some to the minor. And the minor can't own property. Right. So then all of a sudden we have a guardianship of this minor state. So there's two proceedings going, the minor gets their own attorney, and it just becomes really expensive. But the main problem is what's going to happen to the surviving spouse. All of her money, their money, got split in half, and that includes appreciation on separate property, income on separate property. It's the financial effect of having a divorce. Because everything that you thought was yours gets cut in half. So then, what about separate property? So his separate real property, so if he owns a house, like another, they don't marry or vacation home or something, she gets a 1/3 life estate. So what that means is she has the legal right to occupy that place for the duration of her life. But then she's also on the hook for paying 1/3 of the property taxes and the mortgage and the insurance. So all of a sudden she has less money that's hers and an additional expense. And then you can't really see, but his separate personal property, and personal property includes like furniture, jewelry, collections, but it also includes bank accounts of businesses. So then all of his separate personal property goes 1/3 to the spouse and 2/3 to the kids, and that includes the adult kids from a prior marriage and the minor. And my uncle had a business. He was a realtor, and he was a broker, like a real estate thing. There's no way that he would have wanted his wife to have 1/3 and his 3 kids to split it to the other 2 with him. So all of a sudden, because he didn't have an estate plan, now his wife, she had hoped to retire, and she's gonna work for longer. And her minor child, she had to get guardianship of the child's estate, and she has to file an annual accounting with the court every year, certifying how she spent that money for the child's benefit. So it's administratively very expensive to keep up, and it just is really detrimental to those circumstances. And so this is the most extreme example, and I just think about it a lot because it happened to my uncle, well, to his wife. This is a very extreme example of how the state of Texas doesn't always get it. So it really is important for you if you're in a blended family, or if there's any kind of complicating factor. This is a strong argument to get something in place. Yes, go ahead.
She was asked around money, like.
So in this particular scenario, they had a joint account. And so she didn't notify the bank that he had died right away because she needed to use that money to pay the mortgage and buy her kid, buy groceries or whatever. So she used the joint account, but then the adult daughters got upset because she had been using some of that money belongs to the estate, which then belongs to them. And so they ended up having kind of a fight about it in court, and they ended up doing what's called a family settlement agreement, where they kind of agreed on final numbers to be paid out. So it is risky, and it's helpful in this scenario if you have your, like, an account with just your name on it, so that you have some kind of funds. But a fight like this could take months, and most people don't have a separate account with enough money to get them through an expensive legal fight, and also for months. Lynn, did you have a question?
I was just gonna comment that I'm gonna do a small thing, because when my husband passed, we had no will.
Yeah.
But we didn't have children.
Mhm.
But above and beyond.
I have that scenario next.
And they had the. Yeah.
Right.
And I thought it was even.
Yeah.
And the judge is peppering me with questions, and I
Yeah.
got John was sobbing.
It's awful.
And I always say to people, don't.
Yeah. Right.
Get all this stuff taken care of,
Yeah.
because that was one of the worst days in my life.
Yeah.
It happened to one of my best.
Oh, it's awful. Yeah. Mm-hmm.
We stayed. It was a very good relationship, but he couldn't, it took 5 minutes.
Yeah. Yeah.
So he couldn't sell.
Right. And she probably needed the money from the sale. It is common.
Because. You have will.
Mm-hmm. Yeah.
I need to give witness statements.
2 witnesses. Yeah. Yeah. It's a difficult process. I represent one of my favorite clients, just a sweetie, and her dad was engaged, but not married legally. And she's precious, and I love her. She's 25. And this fiance, when her dad, my client's dad, when he was in a coma, dying from cancer, the fiance bought rings and put rings on their fingers, took a selfie, and posted on Instagram, like, we're married, love you so much. Because that was the date that they were going to get married. They were engaged to be married on that date, but he was in a coma. And then all of a sudden, so my client, the daughter, files the heirship determination to determine who the heirs are. And then the fiance filed a common law spouse claim saying that she was entitled to all this stuff. And it was awful. I'm sorry? Well, they were engaged, but then he became very sick before they got married. And so they never got married.
Oh,
Yes. No, the dad was engaged to the fiance, but then he became very sick before they could get married. So they didn't get married. But then the fiance said that they did get married and that she was entitled to all this stuff. It was really bad. Yeah.
just while we're on it, people behaving badly. I have a plain old will.
Mm-hmm.
And I know how people can switch and like come at you and cause trouble.
Mm-hmm.
Do I need to put something in that will specifically stating that I don't want my brother to have anything? Because I worry that he might try and come back and challenge things. Is it easy to challenge a will, or is that not likely to happen?
Well, I think that is really a question of what is your brother like? Because is it easy to challenge a will? Anybody can write a letter to the court and file it with the clerk's office and say, I challenge this will. But if they don't have a lawyer, or if they're not gonna, it just depends, right? Like, if you have a valid will that you wrote while you're of sound mind and healthy, naming someone else that gets all your stuff, your best friend, that's a valid legal will. So could he technically file a contest? Yes, he could. But he has to prove that you were incapacitated while you wrote the will, that you lacked the capacity to write the document, or that you were unduly influenced by your best friend, like, well, the best friend was sleeping with her and shielding her from me, keeping her, like, you have to show that there was a real reason why that will wasn't real, or it was a forgery. So if he called an attorney saying, I want to contest this will, most attorneys would say, well, why? Did she lack capacity? Was there undue influence? Is it a forgery? Like, did the best friend murder her? But like, unless most attorneys would say, you're just mad, you can't actually get anything. So practically, if he did file a contest, what would probably happen is hypothetical best friend would call him and say, what's going on? Do you just want money and you'll go away? If so, will you take $10,000? Woo! Woo! That's bad. Feeling kind of crazy. I mean, you can do, yeah. Yeah. I think it's, yeah. So most likely, most likely a lawyer would be like, that's a frivolous claim. I don't want to look bad in front of the judge. I'm not filing this for you. So if he filed the thing by himself, maybe he could get a hearing and represent himself and, be pissy. And then the judge would be like,
And he has to come.
right.
Yeah.
And so worst case scenario is that your best friend and your brother enter into a settlement agreement and she pays him $10,000 to go away. But more likely is that it would never happen. Yes. Yeah. Well,
If anything makes sense. So I want the best prefers is for some reason it doesn't work. Charity goes through this major. Yeah, I was gonna say, can you divorce your brother?
I mean, that sounds weird.
disinherit. Yeah, you can disinherit your brother. You can say, it is my intention that my brother not receive any gift under this will because of the benefits that he's received from me during his life. For such reason, my executor should treat him as having predeceased me. Fine, you can do that. You don't have to do that, but you can. It's not necessary, but you can. Yeah, good questions. Okay, that's my first scenario, this one, my uncle. So then there are other scenarios under the common law, under the state of Texas law, where your stuff would go. I'm just gonna come over here. See. So, for example, if you do have a surviving spouse, but you don't have kids, but you have parents, you have brothers and sisters, then this is how the law splits it up. But it's still complicated. So, separate personal property, so businesses, bank accounts, all of them would go to the spouse. But separate real property, some of it reverts back to their remaining relatives. So mother and father would get a quarter each and the surviving spouse would get half. So there is still the state of Texas, like the law is, it's kind of, what's the thing? It's focused on prioritizing. And so if you get married and your spouse owned a lake house before you got married, property, and then died, kids, then you wouldn't get the lake house, you would get a slice of the lake house. You could get the lake house if you had no siblings that are surviving and their parents. But a lot of the time, things get spliced and died. I don't know what your relationship is like with your in, but my relationship. And applies to them. And then the spouse gets all of the community property. So it's not like, it's not the same as a financial divorce in this instance if you don't have kids, but it still could really impact your life. If you want to sell that lake house, but mom and dad don't want to sell the lake house, then you can't sell the lake house except to them, because you can only sell your half. And they're not gonna buy your fair market value. Why would they do that? So there's just, it just becomes complicated when you don't have. Okay. And then unmarried person with kids, it all goes to the kids. Kind of a boring one, easy. And then an unmarried person with no kids, it gets split between parents. But if one parent predeceases, then it's half to siblings and half to the surviving parent. And that's one I think is more intuitive. But some people have a bad relationship with their parents and or their siblings. Yeah, sorry, I'm really picking on you, Lynn. Sorry. Or their siblings. Yeah, sorry to your brother. And so, you know, I guess my point in showing you all these charts is just think about what the law actually says. Most people don't know what the law actually says. Think about what the law actually says. And then if that does not reflect what you want, then you got to do something about it. So what do I think you should do about it? I think you should make a will, probably. So I have two hypothetical will charts that I made for you to look at. And I like charts because I'm a visual learner. So here's a hypothetical will that a lawyer would write. So this example is Taylor Swift. So while Taylor is alive, her will is just a piece of paper, has no enforceable legal effect. But when Taylor dies, and that's this dotted line, yeah, please live forever. Please don't live me, Taylor. So when she dies, there's this little flag here is for estate taxes because she has a tax estate. So in the US, there's a federal estate tax, which is also sometimes called a will tax. And this year, the federal estate tax exemption is $13.6 million. So anyone with less than $13.6 million is under the exemption amount that doesn't have to pay estate taxes. That's nice. Most people don't have to pay estate taxes because they have less than $13.6 million. But Taylor has more, I think. I Googled it. And so she would pay estate taxes, and then after those are paid, what's left? And I just made this up. She did. She's not my client. Then her stuff, all of her remaining estate after expenses and taxes are paid, would go into two trusts for Meredith and Olivia. And if you're a real Swiftie, you can make a trust for the cat. But pretend that they're her kids. So we put these trusts into place for Olivia and Meredith. And Selena Gomez is probably going to be the trustee of the trust until the kids reach a certain age, maybe like 30. Maybe they can become co-trustees with Selena when they turn 30, and then when they turn 35, they can become sole trustee of the trust. And why would we put these into trust for Olivia and Meredith? Well, they're minors, and so we want it to be in a trust so that we can avoid the need for a guardianship. But we talked a little bit about this earlier. When you have a trust that breaks those three strains of ownership or trusts, a testamentary trust created under someone's will, that is a trust. Meaning, whatever's in this trust is going to be protected from creditors, divorces, and lawsuits. So, hypothetically, Olivia was a person on Gavin, and she got married, and then she got divorced. Everything inside her trust would be exempt, and the court wouldn't be able to split this up in a divorce proceeding. Or if she got sued, no one would be able to recover in a lawsuit the assets. So it's nice. It's nice to set up a trust for your descendants or your beneficiaries if you can, because of the benefit. The downside of doing this is that this trust is a separate taxable entity from Olivia, and Meredith is a separate taxable entity from Meredith. So it files. And so you need a CPA to help you do it, and your trustee is on the hook until you turn 30, you're old. So there's an administrative cost associated with that. So you wouldn't want to set up a trust for $100. You would probably only want to set up a trust if you were going to put a significant estate into it, like, you know, if like $50,000 or $100,000 or more. Otherwise, the trust is going to get eaten up. CPAs. So this is kind of like a simple plan for an unmarried person kids. Do we have any questions about this?
You could create a trust.
Under your will, but they don't take effect until after. Yes, so this is like neurological from top to bottom.
And you do this, my, I'm before, so they can't, they are entitled to. That. Okay. And you kind of, what I'm gonna want them, you don't want them to just 18 and hundreds of thousands of dollars.
Like, imagine that you pass away unexpectedly before your kids turn, before they're adults, and you don't have a in place. But what would happen is the court would appoint a guardian in your state to hold on to those funds until they turn 18, and then they get a check to the birthday for that. When I was 18, I got an orphanage in Africa. Now I'm a lawyer, so I mean, and I really wanted to give all that money away here on a crazy trip, and that's really stupid. So trusts are nice because you get to decide, do I want Olivia to be her own trustee when she's 18? Do I want her to be her own trustee when she's 35? Or maybe one of your kids, and this is pretty common, I would say, among my clients, if they have multiple kids, there's usually one kid who's really responsible, and then there's often a kid who's a little bit less responsible, and maybe, you know, has some kind of free spirit, I would say, or maybe a problem, yeah. Or maybe you have like boss star. You're thinking, but maybe you marry someone and you just think this is not. And so that's another reason you might want to put it into a trust and name someone else the trustee until they join a certain age. And we don't want to control everything for our kids. We want to make sure that our kids grow up and learn how to do things for themselves. But maybe we wait until they're a little bit older. So that's the way that I often recommend.
I had a friend who gets shocked every time he gets to the age, like at 21, got it done, 28, 30, and if he checks them in.
Yeah, you can do that. The issue, so what I typically, the language I typically include, yeah, it's in here, it's small, is that the trust exists to support their health, education, maintenance, and support. Health, education, maintenance, and support, it's also called HEMS, health, education, and support. That's a ascertaining mistake according to the code. So that is a one special way that you can make a trust. You can give the trustee discretion for health, education, maintenance, and support. Those are kind of the magic words in that like to see to keep this all protected from creditors. If you have a distribution standard like 25, 30, 35, and you get $10,000 or
Well, he got money every day.
must be nice, but the problem is that money, all those distributions are subject to credit. So if this person was getting sued or had debt, then he could get sued every month to get that money, and that would just be taken from him. So any distributions that are outside of him are typically, and this is like not part of the school, but they're often, they will become subject to creditors' lawsuits, divorce. So if you have a really mean creditor who's gonna follow you around and wait till you get that mailbox money, they can't grab it. So I don't typically encourage like mailbox money provisions, like monthly distributions or age distributions, because one of my friends just kept getting married when he got that big age, like he would, yeah, that's what one of my clients kept marrying stripper. Like every 5 years when he got a new distribution, he spend a bunch of money, marry a stripper, they will go through, blow through all the money, get divorced, and then he would be working at a pizza place until he could get his next big distribution, and he's been married 4 times. So I creative provisions can encourage unintentionally raise their that behavior. I know, right? Wow. Did I miss a question? No, okay, great. Okay, and then I have another will plan. Yeah. For a married person, Jay-Z, for example. So if you're married and you have multiple kids, like Jay-Z and Beyonce, then your will is gonna be longer. the families. So, Beyonce's will. So if Beyonce dies, but Jay-Z survives, well, Beyonce knows that Jay-Z could go get another wife, and then he could spend all hard-earned money on this other wife. So I was planning for Beyonce, and this is like, this is simplified. I would do that. I do more for Beyonce. So all of Beyonce's community property and any of her separate property would go into a trust for Jay-Z's benefit. Why do we put it into a trust? Because there are rules with a trust. So rules, meaning there's specific things that he can use this money for, but he cannot give it away to a new wife. And if he gets a new wife, then who's gonna be the trustee of the trust? Solange, Beyonce's sister. Because we don't want Jay-Z just using all of Beyonce's community property and her separate property to take this new wife to Bollywood. We want this money to benefit Blue Ivy, Ruby, and Sir. And so oftentimes clients who are married will put something like this into place where instead of giving everything directly to the spouse outside of trust, what's in their name, it would go into a trust that has some rules attached. And that way it protects what's in here from the surviving spouse's potential thefts. So that's another, so there's an additional layer. So let's say that Jay-Z survived Beyonce. So she gives everything into Jay-Z's trust. Then she gives, she names his her 401k, fine. And she gives all her jewelry and her stuff to Jay-Z. He can have that, fine. But her everything is going into trust. And that way, like I said, if he gets remarried or if he gets sued or whatever, her house stays protected. And he doesn't get to choose where it goes. It's gonna go to these three kids. And then it'll go into trust for Blue Ivy, Rumi, and Sir, with similar rules, because we don't want Blue Ivy to get everything her she turns 18, even though she's very precocious and talented. We want her to learn how to manage her money and be smart. So Solange would be the trustee of these resulting trusts until kids turn 30. So this is, and then here is where the estate taxes come in, because gifts between spouses are, there's an unlimited spousal deduction, so estate taxes don't kick in until the second spouse is dead. So this is a more beefy plan, but this is what I might recommend to someone who's married who has a concern. Show their thoughts about this. Feel pretty good? Okay, good. Oh, thank you. Okay, so a quick recap of what we've talked about. I really do think that everyone needs an estate plan, and depending on your life circumstances and your preferences, that could be something that you do yourself for free, or it might be something that you need a lawyer to help you with. But if you don't make one, then the consequences can be really severe for your loved ones. An estate plan is not just a will or a trust. It should cover emergencies, incapacities, and death. And then because you have worked so hard to earn what you have, it's just important to have a plan and make sure that everything is going to happen and go where you want it to go, and that the right people are in charge. So yeah, make an estate plan. And that is my whole presentation. So yeah. Hit me with some questions.
Know how much.
Yeah.
Is it like percentage that? Is that what you brought? Percentage of the assets goes to this and this.
Yeah. So usually people want to split things into equal shares based on their kids, but if that wasn't the case for you, then you could instead say 10% to my sister, 10% to my brother, and the remainder to charity. Yeah. You can do that, or you can make a cash gift and say $10,000 to my sister, $10,000 to my brother, and the remainder to a charity. And that is actually easier because if you think about valuing a percentage, like it's hard for your executor to know, like, oh, do I need to get everything she owned appraised? What about this painting? What about this china? What about this couch? And so cash gifts are often more simple to give. You just want to be careful that you don't give like really big cash gifts and then there's nothing left at the end for the charity. So if you want to give a small gift, like $5,000 or $10,000, then that's great to use a cash number instead of a percentage. But if it's like, yeah, pretty equal shares, 25, 25, 25, 25, percentages are great. You can also use fractions. We don't discriminate.
A question. Could you advise to choose a corporate trustee?
Oh, Marla's fancy. Well, remember, this is not legal advice. I'm just giving.
A corporate trustee?
I'll tell you what it is. So remember, I'm not giving legal advice, just general advice. But a corporate trustee is someone who you name as an executor or a trustee of a trust that you create that's like a bank or a trust company. So for example, if you are single and you have 2 kids, and one of your kids is really responsible and the other one is a free spirit, and you don't want to make your responsible kid be the trustee of the siblings trust. And actually, this is like a situation with the one who keeps marrying strippers. Like his siblings don't want to keep telling him no all the time. Like, no, no, no. It strains their relationship. So instead, they might want to name a bank or a trust company or a professional trustee, which is known as a corporate trustee or a corporate fiduciary, to serve as the trustee of that person's trust. So I think this is a really personal decision because you're choosing someone that you don't know to serve as trustee of a trust for someone that you love, or you wouldn't be giving them money, right? So I typically recommend if you want to name a corporate trustee, you should look at their fee structure. Most trustees list their fee structures on the internet, like Wells Fargo, Frost, Cumberland Trust, Argent Trust, Cadence Bank. All of their fee schedules are public. And I just would have meetings with their person, and just talk to them about it. Some people care a lot about if they work with a wealth advisor or like the finance guy, they want to keep that guy in place. Some trust companies require taking assets under management into their own private bank. So if it's important for you to keep the same team in place, then you'll want to choose a corporate trustee that authorizes directed trusts, so you can keep your same finance team. Cumberland Trust does that, and I really like them. But it just depends. Like certain companies have a minimum of like $3 million. So if your trust is less than 3 million, they won't take it. But some of them have a lower minimum, like 250,000. So it's hard to find the right trust company to work with. Ultimately, it depends on what exactly you need and how much you're working with. Good question. Yeah.
Executor also be.
Mm-hmm. Yes, you can use a corporate to be your executor of your estate. I see this often. Sorry?
I'm trying to.
Yeah. Yes, a lot of the times clients who don't have kids, who are single, use a corporate executor. And it's great. A lot of other times a surviving spouse with 3 kids who don't get along will use a corporate. Because like, think about going through the house and picking personal property. If everything goes equally and there's 3 kids and they can't agree on who gets the piano and who gets the. Right. And actually, most of the fighting happens around like jewelry and art and not as much about like bank accounts, because it's like the sentimental stuff that you can't put a number on it. And so if you have a contentious family, or if you're worried like, well, who's going to do it, then a corporate is a good idea, but just be advised that it costs money to hire someone to do it. Yeah.
I'm interested in this example at the very beginning when
Yeah.
you sign, all the documents.
Yeah.
If there's somebody that's younger and like maybe put together an estate plan,
Mhm.
does that estate plan get updated like as you grow older. like,
Yeah.
you
Mhm.
have more to want to protect, is that like a regularly updated thing? Or do you once and then?
I mean, look, would it be great if everyone looked at their estate plan on January 1st when they make their New Year's resolutions and, take stock of their life for this next year? That'd be great. Most people don't. If I usually recommend to clients that they check their estate plan when a big life event has happened, like if you got married or you got divorced or you had a kid or you bought a house. I also recommend looking at it like every 2 to 5 years because your circumstances and your estate change. So maybe you have more kids, or maybe your best friend that you really trust, that you named to be the guardian of your minor kids, married some idiot that you hate. And so you don't want her to take care of your kids if you die because you don't want the husband to be around. So I think just because life is always changing and when it's happening, it feels so gradual. But 5 years, you look back and you realize like, oh, my trusted people have changed, or my assets have really grown and maybe it's time to think about some tax planning, or I have kids now and I want to make sure that there's a trust set up for them under my will in case I die when they're minors. So yeah, every 2 to 5 years or after a big life event is a good rule of thumb. Yeah. Yeah.
So for Virginians.
Mhm.
Yes. One has the.
Mhm.
So you said it's,
Yes, there's 3 ways to transfer property after death: by contract, like a beneficiary designation or a pay on death, under your will through probate, or under common law, which is through an heirship determination where the court decides where it goes. Contracts trump wills, and that could be a good thing or it could be a bad thing. So I had a client, not a client, a potential client call saying, I hate my husband, we're never getting divorced, but I want to make sure that he doesn't get anything under my will and that everything goes to my daughters from my prior marriage. And I was like, I can't really help you with that because you're married. So everything is community. Most of your property is community property. You've been married for 16 years. And so you can only give away what you own, which is half. And so you can give away your half to your daughters, but you can't give all of it away. That's, you're trying to do like a financial divorce with an estate plan, but you can't actually do it unless both spouses agree. So she wanted to name her daughters as a beneficiary on her biggest asset, which was a retirement account. Or she had won it in her divorce from her prior marriage. And it was some vested stock options that he had received from an employer that were worth like $2 million. Not in a retirement account, but in an account with some strings on it. So she wanted to name her daughters as the beneficiary on this account. But the problem is, even though she won that as part of her divorce decree from her prior marriage before she got married, since the date that she got it to today, which was like almost, I think like 19 years later, those shares have increased significantly in value. So it's not just her separate property because all of that appreciation is community property. And so most banks and financial institutions have a section on the form of, if you're married, both spouses need to sign this, otherwise it's not valid. So she had signed that and sent it to me and saying, look, I designated you as a beneficiary, so it's fine. And I ultimately had to tell her, like, it's actually not fine, and that's not going to hold up in court if you pass away, because it's not valid without your spouse's consent. And she wouldn't authorize me to talk to her spouse because she was like, I hate him. So I had to ultimately tell her that I couldn't help her. And so, yeah, beneficiary designations do trump wills, but only if they're done properly, executed properly. So if you're married, your spouse needs to sign it. If you're not married, do whatever you want, fire away. Yeah.
I'm not. But my investment accounts, they require me for the beneficiary, which is important. I don't want her to have money. That's not it. So how do is there something in my will that I designate she does without sharing or not?
You can remove that beneficiary designation. So certain some banks require a beneficiary designation. So you can designate your estate as the beneficiary, and then it will pass under your will. I don't recommend that for retirement assets because there are special like pre-tax, post-tax rules, and you get a tax benefit with retirement accounts like IRAs and 401ks. So I don't recommend naming your estate as the beneficiary for retirement type accounts, but for brokerage accounts, if the institution requires a beneficiary and you don't want it to just pass to one person, the options are you name multiple people with percentages, or you just name your estate as the beneficiary. And then it'll go under your will. When we get trigger happy with beneficiary designations, we do create certain issues. And this doesn't apply to everyone, but if you have a tax plan in place, like if you have a special tax plan, or, oh wait, if you're Beyonce, hold on, where's Beyonce? There she is. If you're Beyonce and you name Jay-Z as your beneficiary on your brokerage account, it won't go into his marital trust. It'll go to Jay-Z individually. So then you lose the benefits of the trust because he gets it in his individual name. So when you are making beneficiary designations, think about what percentage of my estate am I taking out of probate and passing under contract? Is that really what I want? So like Beyonce, hypothetically, doesn't want Jay-Z to have everything in his name because she wants to protect it against remarriage or divorce or whatever. So she puts it into a trust, but if she names him as a beneficiary on her account, then it won't go into that trust. It'll just go into his name.
Everything but your retirement.
Yeah,
Retirement accounts have a name.
it's helpful if your retirement accounts have a named beneficiary because certain beneficiaries, there's special classes of beneficiaries who get a longer stretch out of required minimum distributions. And so it's nice if you can name those, yeah, yes.
But other things. What is?
Same thing,
Your bank statement,
yeah, same deal.
and then. Bank accounts, homes, on that kind of thing. It's better to say like, lease of the estate or whatever.
Well, most people don't name a beneficiary, well, okay. We're getting real specific, we're slicing some hairs here, so, no, it's okay. So when we start playing this potato, like yes, no game, we get into risky territory. Because there are ways that you can name a beneficiary on your car so that upon your death, title transfers to someone else. And you can execute a deed, you could execute a transfer on death deed or a ladybird deed that would transfer your house upon your death automatically. And you can put someone on your bank account, pay on death or transfer on death or with right of survivorship so that all your assets pass by contract. But the risk of doing that is that you forget about one or two assets. So most people don't know, like they don't have a clear picture of where everything that they own is. For example, when I was teaching high school, I taught at one school in Tennessee for 2 years, and then I moved back to Austin and I taught at this different public school here. But my retirement account under my public school teacher benefits was up in Tennessee, and I never got login information to log into that account, and I didn't really know where that money was kept. And I kind of honestly forgot about it because it wasn't that much. I didn't make that much money because I was a public school teacher. I moved to Texas, I taught for a year. I did know where that 401k account was because Texas retirement teacher benefits sends me like 100 mailers a day. And so I know about that one, but I forgot about the one in Tennessee. And then I went to law school and I was doing lawyer stuff and I became a lawyer and I opened this account. And I forgot about that Tennessee account. And I think there's maybe like $2,500 in there. Like it's not that much money, but it's not nothing. I mean, I don't want it to just be floating around in Tennessee. But for me to find it, I had to call my old principal who had moved schools. And then she told me to call the district. And then I called the district and left a message and no one got back to me for 3 weeks. And then they told me, oh, I think it's with Mass Mutual. So I called Mass Mutual, but I didn't know my employer's ID. And it took like 8 weeks for me to track down this $2,500 retirement account. And ultimately I got it rolled over into my, into like a rollover IRA, cool, set, done. But most people aren't going to take the time to go find it. So if I had designated a beneficiary on that account at that time, I was unmarried, I probably would have named my cousin Tess, because she's my favorite. But now I would want to name my husband. And so most people don't keep good track or good records of where all of their assets are. So I typically don't recommend an asset by asset contract approach, just because if you forget something, then you have to go through either probate or an heirship determination to claim that missing thing that you forgot about.
So you leave it blank.
Leave it blank. And there's not like a place, like when you buy a house, there's no section saying designated beneficiary on this house. And the same is true for checking and savings accounts. Most places don't ask you for that. They'll ask you with brokerage accounts sometimes or with retirement accounts, but not always. And so when in doubt, if you have a will, just let it pass through your will, unless there's a tax benefit for naming a beneficiary, like a life insurance policy or a retirement account. This is kind of my general suggestion. Yes.
Yeah.
Okay.
Or just update the picture of there, and then she'll talk to the word. And I think for because she was limit doesn't be attached. And you explain this back to keep everything together.
Well, so there are, without knowing anything about this family, my kind of things that I'm thinking about are, does this elderly parent receive Medicaid benefits? Okay, so that's an issue. And are there unpaid income taxes or property taxes? So there's this program called the Medicaid Estate Recovery Program, where if you receive Medicaid benefits and you take out more, then upon your death, Medicaid will come back and grab things out of your estate to cover the payment. So for people who can afford Medicare or supplemental insurance for end-of-life care, or who receive a pension and get Social Security and have a retirement account, and they don't need Medicaid, then that's not a problem. But if there is Medicaid involved, then probably the best thing to do is call a specialist who does Medicaid planning, and they'll probably tell your friend that the parent needs to execute a ladybird deed and do it now. And that's one way to kind of carve things out of what Medicaid recovery can grab, MERP, the Medicaid Estate Recovery Program. So that gets really complicated when we start talking about Medicaid. Yeah, if there's no Medicaid, leave it in the will. If there's Medicaid, call a lawyer. Yeah, yes. Mm-hmm. Mm-hmm.
But it's
The bank had. The bank was legally by law.
Mm-hmm. Yeah.
that actually. That's just what you got.
Well, and like, if this brother doesn't have a power of attorney authorizing him to do that, then it would be pretty, I mean, not pretty easy, take time and cost money, but it would be possible for your sister to show that he fraudulently took action without authorization after your death, which is illegal. So not only would that designation be terminated because it's fraudulent, but then he would get punitive damages and have to pay extra because he messed up. Yeah. Good question. Yeah.
So to the will, you need to write it.
A holographic will is typically the kind of will that people make themselves that goes through probate with the least amount of issues. So, and that's a fully handwritten will. The reason for that is because the evidentiary standard that you have to meet to be considered a valid will with no problems, if it's typed, is very high. But if it's handwritten, it's a very low, easy burden. So a lot of people will, during COVID especially, and I graduated from law school in 2021, and I worked for the probate court. I clerked for Judge Herman in Travis County during my last year of law school. So from 2020 to 2021. And part of what I was in charge of was reviewing wills as they were submitted as people died. And as you can imagine, during COVID, there was a lot of fear and uncertainty. So a lot more people than in the past started using like LegalZoom or like different legal, kind of like low-cost legal aids that are electronic. A lot of people were doing those DIY wills that are forms that you fill out. And unfortunately, so I probably reviewed 84 or 85 of those LegalZoom wills while I was at the court. And only one of them made it through probate without requiring additional evidence or being thrown out or having a partial heirship. And that's mostly because people either didn't fill out the form correctly or they didn't execute the document correctly. So wills that are typed have to be witnessed by 2 disinterested witnesses and notarized. And there's special language that you have to include and like an oath that you're supposed to take, certifying that you sign this will in the presence of 2 disinterested witnesses. They sign in your presence at your request, that you're over the age of 18 and of sound mind, that you make the will voluntarily as your free act and deed, and then that they watch you do it, you sign, and then they certify that they watched you sign the will, you sign in their presence, they sign in your presence as at your request as witnesses, that you declare to them that you made this will as your free act and deed, and you declare that it's your will, that you're over the age of 18 of sound mind, and that they're over the age of 14. And if any of that language is missing, then you need additional evidence to prove that it's a valid will. So it's easier to do a handwritten will because you don't have to have all that in there. You just have to name an executor, hopefully an independent executor. You have to give away all of your property, everything, and then sign and date it. And they say that it's your will. That's usually good enough to get through. So that's why I typically, if people are thinking about writing their own wills, I just tell them to handwrite it and then just keep the original. Yeah.
If something happens to parents, is that
Are we talking about an adult child or a minor child? It's going to depend on how that account is titled. So if your parents open this account for you when you're a little kid, that could be done a couple of ways. It could be a custodial account where it's under your social security number, but your parents have custodianship of it until you turn 21. Or it could be like a joint account where they really are the primary and you're the secondary. When you turn 18, you should get that account. Or maybe your name is not on at all and they just kind of said like, oh yeah, this is the account for baby girl. So depending on what the title of the account says, and that would be found on the signature card. So you would need to request a copy of the signature card from the bank and see what it says, and that would explain. So it depends on how much is in there. And again, if you're joint owners or if it's a beneficiary account, depends on what the title says. So if there's a joint ownership on, like if one of the parents has died and there's joint ownership, the signature card will tell you if it's a transfer on death or if it has right of survivorship. So if one parent opens this account for baby girl and then the parent dies and baby girl's an adult, then if it's a transfer on death or a right of survivorship account, then baby girl's the legal owner of the account. But if that's not on the signature card, then it becomes a little more complicated. Mhm. It depends. Trying so hard. So if okay, there's a couple of rules. Well, so mom's half, if it's a joint ownership account, if it's joint with right of survivorship, then mom's half transfers to you automatically. But if it's not with right of survivorship, or if after she got married, she deposited a ton of money in that account, then there might be an issue. Because the presumption, depending on how it's titled, might be that you own the account 50-50, or it might be that you're just an authorized signer. So who owns what's in the account? That's gonna be on the signature card. And if mom got remarried and then she was like, don't tell my new husband, I'm putting all this money in there, then you might run into a tax issue and you might run into a community property issue. So when you're married, like I mentioned, in Texas, we're a community property state. So all of what you receive during the marriage is presumed to be community property. So mom owns half and new husband owns half of everything. And so if mom was sneaking $100,000 or a lot of money into this account after marriage, then new husband could sue for alienation of the community estate. So it's just gonna depend. Look at that signature card, and if there is an issue, and if new husband is like friendly, then maybe he'll sign off on a beneficiary designation, so that can be special for baby girl. That's my thought.
I think we have time for maybe 1 or 2 questions. When do we have any more?
No. The last one.